Well, one of the first things is to determine what countries the subject of the breach reside in. It's not unusual with a large credit card breach, at least as a secondary inquiry, to ask about not only what states, but what countries you might have individuals in. And that prompts an entire new exercise in and of itself. Most U.S. multinationals will not be keen on notifying abroad, but some will begin to look more carefully or ask us to look more critically at are there any data breach notification obligations in those countries, either notifications to the Data Protection Authority or to individuals or both. And if so, how do you do it? You can have a call center abroad, you can use forensics in those countries. All of that prompts a very intense exercise into what those countries' laws are and who you're going to even use to advise you there.
Collection, use, and disclosure of personal information in Canada is governed by the Personal Information and Electronic Documents Act, which we all refer to as PIPEDA. It covers the private sector across the country, with the exception of 3 provinces, which essentially mirror the legislation. There are no mandatory reporting requirements in Canada for a privacy breach, with the exception of the province of Alberta. So essentially the only breaches which come to the attention of the public are ones which are either voluntarily disclosed or they become part of the public domain because somebody who is affected by the breach brings it to the attention of the media or the privacy commissioner. The collection and use of data in Canada, which is stored anywhere else in the world, is also governed by PIPEDA. So if there is some kind of a leak or breach of privacy in the United States through cloud or through somewhere else in the world where the information is stored, there is a breach of the PIPEDA legislation, but again, there's no mandatory reporting requirement. So essentially, you would have to look at the legislation where the breach occurs to determine whether or not there is a reporting obligation in that country or jurisdiction.
Gonzalo, is there anything you'd like to add to that dilemma?
Yeah, I mean, one of the things you also have to consider when you're determining whether or not to notify, just looking at the statute, or if there's an applicable statute or if there's no statute, may not indicate a mandatory notification requirement, but in a lot of jurisdictions, particularly smaller jurisdictions, you have to look beyond the statute. In Brazil, for example, you should look to consumer protection statutes. There's constitutional requirements. There are other statutes that are not necessarily immediately obvious that would give rise to a notification requirement as a matter of common practice rather than as a matter of statutory obligation. Other things to bear in mind are the different classifications of data in various jurisdictions, depending on what is put out into the public through the breach. If it's a jurisdiction that makes a distinction between sensitive personal information and ordinary personal information, you may have a reporting requirement in one context but not the other. And even that's not so simple. For example, if you're a financial institution and if the breach is in a jurisdiction like Japan, the regulations that govern the release of sensitive personal information are contained in the Japanese Financial Services Agency's guidelines, not in the privacy statute. So you really need local expertise, somebody who's thinking about the various laws that could be impacted by a breach, particularly where there's no statute.
Well, the number one issue has been mentioned. You've got to get local advice. You've got to get the local experts. You've got to pay attention to all the borders. Just using Canada as an example, Quebec is notably quite different in not only the laws, civil code as opposed to common law, but the approach of the judiciary is much more consumer focused, and you want to understand not only the technical issues that you might be facing, but some of the nuanced issues of any borders that you're having to cross. What I'm finding is I'm often involved in debates where this is really much more than just a data breach. It's the reputation of the company and other things that go well beyond what an insurance policy can provide. I mean, ultimately, insurance policy provides funds for various services and experts, but it has to be a conversation that takes place together. You've got all the right people in the room, all the right people participating in that discussion, because it's their breach.
I think it's important, firstly, to look at their own crisis management plans and what they've already got in place should they have a data breach, whatever people want to call it. And I think once you can look at that plan, and then you can mirror against it what sort of services and applications that you can give to them to help them mitigate their issues with cross-border data transfer. So what we try to do is to analyse from the application where their jurisdictions are, their main jurisdictions are, and then we try and work with them to select vendors that will work across the borders that they need to work on.
I mean, I guess you want to sit with the client, you want to discuss, and Matt, we were talking before, and you brought up a good point, and it's sort of a question that we always query is, what are you guys able to do in the absence of insurance? And I think it's sort of an overarching theme on this panel is sort of the cross-border mentality, the data transfers, data policies in each individual jurisdiction, and whether it's the client handling that in the cloud or is that they actually have that data in servers at each individual country. And it's building and selecting the vendors in that manner. And what we're finding specifically in Canada is when you speak with a client, they go, well, yes, we have a vendor contract for our systems and our IT approach, and it's probably covered under that. And then again, throughout all the panels that I've been listening to, it's basically, the contract, once you get right into it, there is no setup for it. There is stuff like that. So they're quite far behind, and it is a very troubling aspect when we look at it on an underwriting basis, because you want to see this. You want to see them have the forefront of setting up the crisis management process, have that data policy in place.